Welcome to the City of Rapid City's Planning Commission October 9th, 2014 meeting. Some housekeeping items. If any member of the audience wishes to speak to an item on the agenda, there are speaker request forms to the left of the dais. Please fill out the request with the agenda number on the item that you wish to speak to and hand it to the secretary. Cell phones and electronic devices. At this time, we'd ask that any member of the audience has a cell phone or other electronic device that you either turn it off or turn the ringer to silence. If you need to take a call, please step out of the hallway so the meeting will not be disrupted. Items 1 through 5 have been placed on the consent calendar and may be approved as a group. Action will be taken on all consent items in accordance with staff recommendation by a single vote. Any item may be removed from the consent calendar by a Planning Commission member, staff member, audience member for separate consideration at this time. The findings of the Planning Commission are recommendations to the City Council. The City Council will make the final decision with the exception of the following items. Item 4, 14 PD 028. The Rapid City Planning Commission's action on this item is final unless any party appeals the decision to the Rapid City Council. All appeals must be submitted in writing to the Community Planning and Development Services Department by the close of business on the 7th full calendar day following action by the Planning Commission. Are there any items 1 through 5 staff would like removed from the consent calendar?
Item number 4.
Yes. Are there any items any Planning Commission or would like removed from the calendar? Are there any items audience members would like removed? I would entertain a motion at this time.
Move to approve with the exception of item.
Second.
Motion's been made and seconded to approve items 1 through 5 with the exception of item number 4. All of those in favor, please say aye.
Aye.
Item number 4.
Good morning. Item number 4 is a final plan development overlay to allow an apartment building in the medium density residential district. The applicant is proposing to construct a 3-story, 12-unit apartment building with a detached garage with 5 stalls. I'll show you a little bit of what's being proposed. Is located on Coalbank Drive. Address is 4660. It's west of Haynes Avenue, and it's south of Auburn Drive. Currently, the property is void of any structural development. There are some apartments to the east and north. Vicinity map shows you Haynes to the east. The applicant is not requesting any exceptions from the minimum requirements of the medium density residential district. Property is zoned medium density residential district and is located within a planned development designation requiring that a final plan development be approved prior to issuance of a building permit. Landscaping, parking is in compliance. We have some elevations of the proposed detached garage and the structure itself. 3 stories, 12 units, and here's a layout showing interior stairwell and 4 units per level. The medium density residential district allows for buildings to be 3 stories or 35 feet. This proposed apartment building meets those criteria. The sign is posted on the property. This is looking into the property from Coalbank Drive. Here we have apartments to the east and to the north. This is looking back along Coalbank Drive to the northeast. To the north, there are apartment buildings in the area, other apartment buildings in the area. This is across the street on Coalbank Drive, and then looking to the terminus and where future development may happen. This is looking from the interior of the site to the property to the east. Properties adjacent, the structures are 2-story. They're also zoned medium-density residential district, which would allow for 3-story structures. Property to the north. And then this is the major drainage easement located along the south side of the property. And that's the single family that's across the major drainage easement to the south, which provides a buffer for those neighbors. And looking along the drainage easement to the west. Staff has pulled this item from the consent agenda because we have received a letter of opposition which was attached to the agenda. We did meet with the neighbor who made the who brought the letter in. Wanted to make a few points about it. One of the complaints was about the notification requirement. It appears that the notification requirement works because the neighbor received notification and was able to set up a meeting with staff, and we tried to address some of his other concerns. Some of the concerns, or a lot of the concerns that were brought up were that the neighbor was not happy with the height, or and some of the other issues such as landscaping. However, the applicant is not requesting any exceptions from the minimum requirements of the medium-density residential district. 3 stories is allowed in the district. Setbacks are all being met. Parking is being provided. Landscaping is being provided in compliance with the zoning ordinance. And the third issue was the drainage from the site. It appears that public works staff this item, when it was brought in, was actually suspended by staff during the review so that the applicant could show that drainage was being accommodated on site, and the applicant did provide a site plan, and public works staff has indicated that the on-site drainage is being dealt with as it should be. I'll show you that plan again. Along the east side of the property is the facility that's being proposed by the applicant. In the letter that was received by staff, drainage that goes from the current property appears to go onto the property to the east. It's vacant right now, so actually by developing this apartment building and installing this drainage feature, it should alleviate any drainage off of the property. With that, staff recommends that the plan development be approved with the stipulations as noted in the staff report. The applicant is here to answer any questions. It does not appear that the person who brought the letter is here. Are there any questions for staff at this time?
Move to approve with stipulations.
Second.
Motion's been made to move and approve. Are there any comments that anyone wishes to make? Karen?
Fletcher, when you visited with the person that was complaining, or the person that lives across the street, did he seem to be satisfied with some of the issues that the most folks have given?
No, he did not.
Okay.
He indicated that he's going to pursue looking at the notification requirements for plan developments, and would be most likely appealing if the planning commission approves the plan development, we'll be appealing it to city council.
Okay. Other than the notification requirements, was there issues that he still, other than the 3 stories? I can understand that, but
there were other requirements or other things that the neighbor wanted to include so that he could review and approve prior to it getting approved. And in actual fact, staff, we enforce what's the minimum requirements of in the zoning ordinance. We do not force more than what's the minimum required.
okay. Thank you.
Any other comments? If not, all those in favor, please say aye.
Aye.
Opposed? Motion passed. Regular agenda items. Item number 6.
Item number 6 is a final plan development overlay to allow a single-family residential development, Copperfield Vistas, 45 single-family lots. Previously, Planning Commission saw Phase 1, which is here. We'll get to. That was approved. This is for Phase 2, which will extend along Summerfield Drive, Conservation Way, and hook up into Homestead as it comes across. You can see that the road is sort of already in there, or where it's going to be. Currently, it's void of any structural development. Here we see this is going to be Phase 2. Planning Commission previously saw Phase 1. And the single-family lots, which all meet the minimum lot size for single-family. Sample elevation, and this is looking from Summerfield Drive to the north to the water tower that's out there, which will be on the, where Homestead Street extends to. This is looking from the property to the east and the existing development. This is looking out into what would basically be Phase 1 from the corner of Summerfield and Conservation. This is looking from the looking from the east to the west, along where the road would go for Conservation Way. And this is looking at some of the development in the neighborhood, which it should be similar to, and looking at property that located to the west.
John?
Sorry.
Okay.
The applicant is requesting an exception to reduce the minimum required front yard setback for 3 lots, which are corner lots located adjacent to Homestead Street. Previously, Planning Commission approved the reduction in the minimum setback along the south side of Homestead Street for Phase 1. However, denied the exception to allow 20-foot setback adjacent to Homestead Street for the north side. And this was because Homestead Street is identified as a collector street, and there were concerns about whether there was would be room for additional improvements in the future should Homestead Street connect and more traffic be put on. Staff is recommending that the 20-foot setback be approved for the 2 lots on the south side of Homestead Street, provided that access is not taken from Homestead Street, and that the 20-foot setback for the lot on the north side of Homestead Street be denied in order to keep the streetscape on the north side consistent. Staff does recommend that the plan development be approved with the stipulations as noted in the staff report. Are there any questions for staff at this time?
John?
Thank you, Madam Chair. Fletcher, I do have some questions. Can you go back to the plat slide? What I want to ask you about is drainage. Seems to be a little bit of concern in the community since everybody's going to have a little drainage reminder twice a year when they go to pay their property tax about how the city approves and handles drainage. And the issues that I'm aware of are that we have some public area drainage that need to be fixed and improved. But also when we improve plats, I'm not sure what the drainage process is by the person bringing the plat forward. Whether we're running it off or whether we're metering and damming or what we're doing with it. So in this particular plat that's coming here, what's the process when somebody brings this forward? And then after it's brought forward and we approve the plat, How do we make sure that each lot, when it's built, runs to some kind of drainage plan so that the next person to build doesn't have a basement full of water?
Ted?
Thank you, Madam Chair. I think you're asking two questions there. The first question is the subdivision drainage. When the subdivision plans are brought in, there's typically a grading plan and then a drainage plan that goes with that. And that drainage plan has to be in compliance with our infrastructure drainage or infrastructure design criteria manual, which has a section specifically on subdivision drainage. After the drainage is designed, reviewed, constructed, then the home builders come in, and then the individual lot drainage is what your second part of your question is, I believe. That's the most difficult thing that we deal with. In fact, we've convened a subcommittee, if you will, to talk about perhaps having future requirements to ensure that the last person building there isn't left holding the bag with their site drainage. So that is a problem that the city struggles with. Other communities do as well, as we understand. We've contacted a couple others, and we're looking at moving in a direction to have some other controls during the building portion or the house building portion of the development phase. I hope that answers your question. If you've got anything more specific, I'll try to address it.
It would, if I could just explore that discussion a little bit further. The second part, I guess probably explaining it as the last lot builder holding the bag is the part. So the city building inspection or your department is trying to figure out how, when the lot is approved, that drainage is going to drain well and in compliance with the original plat, subdivision plan?
That's correct. That is exactly the thing that we're exploring. And currently, we don't, or the building department does not inspect for drainage. The way we're currently structured, the only inspection for drainage is during the subdivision phase or when the platting is done. The individual lot drainage is not looked at. And that's the hurdle that we need to get over, is to have some controls in place so the individual builders on the lots build what was originally intended with the subdivision. And that's the connection that we need to make.
So once you figure out how to, once you figure out, that committee figures out how to do it, is that by ordinance or by, how will you enforce the individual lot drainage to the subdivision plan?
That's exactly what we're exploring, so it'd be premature for me to even speculate on how that's going to be done at this point in time.
But it can't be done at the desk. It's going to require some kind of building code.
Absolutely. It'll either be a ordinance or building code revision or something. We haven't landed on what the solution is.
Thank you. That's what my question was. So, do we know where the city is with, the tax is going to be on the rolls this next go-around? So the city will start collecting. Where's the city with what we're going to do with tax money?
Ed?
The stormwater drainage utility fee that you're speaking about will be for the operation and maintenance and construction of major drainage improvements, major conveyance elements. A subdivision, just as we're speaking about, you collect drainage from multiple lots to get it to a major drainage easement. The city will be responsible for the operation and maintenance of those major drainage easements. The interlot or the between houses drainage that are between two property owners, that's still the property owner's responsibility to maintain that. Back to your question, I believe in 2015, April and October is when the first taxes or fees will be collected on the tax bill. We currently have some funding in place and do have personnel out there working on the major drainages as we speak, maintaining them, repairing them, reducing vegetation, fixing what they can. After next year, we'll have a capital improvement plan that goes along with the stormwater drainage utility fee, where we'll be making other improvements throughout the community.
So as those funds are collected over the time, it'll go through the CIP as to which projects are prioritized for improvement?
Yeah, this is like our water and sewer enterprise funds, the stormwater drainage utility, and it's its own separate enterprise fund, if you will. So it's got its own capital improvement plan, if you will. So it doesn't go through the regular CIP plan or process for streets, government buildings, and so on and so forth. So it's a separate plan altogether.
So I'm on the CIP committee, and we have a streets and drainage fund that we manage.
Correct.
This will be, the stormwater fund will be separately managed.
That's correct.
So will the city continue to fund drainage under the CIP?
I anticipate we'll have a name change to that CIP fund and remove the drainage component out of it.
Thank you. Thank you, Madam Chair.
Andy?
Thank you, Madam Chair. Is this did we see this property once before, I believe, or was it a different phase?
Phase 1.
It was a different phase? Okay, so and then I just want to comment on what John's saying and what Mr. Tech's working on it sounds great, but from a practical sense, it's virtually impossible. I think that the drainage has to be put on the onus of the landowner and the builder, because you're creating a situation where you're going to have builder A, builder B, builder C, and they're all going to have different elevations to which the house is going to be set at, and we're creating a situation in which you would have 2 or 3 full-time staff members trying to compare elevation to elevation to elevation of the house. So from a practical standpoint, I don't see how that works. And I think that and from a cost effectiveness of building, I don't know how it works. So, I think ultimately that responsibility is still going to be put on the builder and the homeowner to make sure that they, create the drainage around the property of their house. So I don't know, maybe some of the members in the audience would agree or disagree with me, but I just would, as you work that through, you might be creating more positions and more government than what is practical, would be my point.
Amanda? John? John, then?
Thank you, Madam Chair. Andy, I understand the complexity of it, and I'm not trying to create more government. I'm just, not only in my own personal situation, but people that I talk to, they just have the problem. And so if I see this and I go buy a lot and I say, I'm going to build on that, but I'm the last builder in, I'm holding the bag, as Dale mentioned earlier, possibly. So I would just like to see that at some point when the occupancy permit is issued, that there's some measurement or some protection for the future lot owner or the next door lot owner, that's part of the inspection. And I don't know that, I understand the practicalities, what you're talking about. 240 lots and last one in, I don't think we're going to measure it to that degree. But I think it's an important part of the inspection for the occupancy permit, and that's my point. Thank you.
Amanda?
Thank you, Madam Chair. May I direct a question to Mr. Dale Tech, please, just for clarification? Dale, just to clarify it, you actually covered 3 different points, and since it was raised for the drainage utility fee, I just want to re-clarify or have you re-clarify the fact that the drainage utility fee is totally separate from subdivisions and then individual lots and building permits being considered.
That's correct, yes.
Can you kind of just run down one more time a summary of the 3 different points we're talking about today, and because I know it's confusing.
Well, the overall subdivision, what we have here before us today is a final plan development for a subdivision. Through that process, as far as the engineering is concerned, or what Public Works deals with, is that the overall drainage in that subdivision is adequately designed per our criteria that we have. Once we're assured of that and the contractor builds that drainage, that infrastructure for conveying flows from all the lots to the designated area, if you will, then you have the individual property owners or builders come in then and start building on lots, and then the drainage from those lots between each lot has to be addressed properly to get to the locations that were originally identified in the subdivision plan. Once that's done and the subdivision's completely built out, you would hopefully have adequate drainage between the homes, going to some area that is what we would consider a major drainage easement that would be a responsibility of the city to operate and maintain because it comes from multiple properties. That's where the stormwater drainage utility fee kicks in, is that money is set aside to operate and maintain those, as well as build other facilities in parts of town that don't have those, that were built prior to the subdivisions requirements that we have today. I hope that helps.
That helps greatly. You explained it so much better than I could have stumbled through it. Thank you so much. And I hope that helps all the viewers that are watching as far as it's not one issue. There's three different multiple points to contributing to this. Thank you, Madam Chair.
John? John? He'll save his breath.
I'll save my question for discussion, Madam Chair.
Is there a second? Second. Motion's been made and seconded. John? Now you don't have a question? Oh, okay, thank you. Okay, all those in favor? Aye. Opposed? Motion passed. Thank you so much, Dale. That was really appreciated. Item number 7.
Thank you. Good morning. Item number 7 is 14P030, final plan development to allow a single-family residence with an oversized garage and storage place or storage area located on 5.5 acres of property at the northern terminus of Villaggio Lane. Let me take you through some slides. You can see the zoning on the property, location, vicinity map, Highway 16 and Catron Boulevard. You can see the property located north of Catron Boulevard. One thing to note here, you've got the public access easement of Villaggio Lane that runs through the property from south to the north and from east to west. And then it's kind of hard to see in detail, but there is a structure located on the property right there. I want you to keep that in mind as we go through the slides. It'll give you a frame of reference for the rest of the development on the property. Here's a site plan for the development of the property. I know with the topography on there it's a little hard to see, but you'll notice there's a single-family residence located right here and a shed located right here. Villaggio Lane runs through the property like this. I'll look at the elevations of the proposed house. You can see the 5-stall garage located attached to the residence. And then this is an elevation of the additional proposed shed. The the requirements for a garage in Rapid City state that you may have either 1,500 square feet of garage and storage space on a property or 30% of the square footage of the household, whichever is larger. In this instance, the threshold is going to be the 30% of the size of the residence. In other words, 2,653 square feet of garage would normally be permitted on a property with a residence of this size. The applicant is asking for 6,413 square feet. Some elevations of the property, signposts on the property. That's the access easement of Villaggio Lane running through the property, give you a frame of reference. And that building is the one that I pointed out on the aerial there in the background. I'll look south on Villaggio Lane to some of the neighboring development. That's on the east side of Villaggio. Closer look at the existing building on the property and the location of the shed, which is essentially going to be across Villaggio Lane from that. I'll look at the existing single-family residence on the west side of Villaggio Lane. I should point out here that a number of the residents in that area have inquired regarding what is being proposed here today. None of them indicated any opposition to the proposal as it is made today. This is a look at the building site for the primary residence on the north side of Villaggio Lane. You can see looking to the north or into North Rapid City from a nice view there. And one more look at the location of where the shed will be on the south side of Villaggio Lane or the access easement. Look from the building sites or the approximate location of the building sites south towards the nearest residential development. And one more look at the building site. It would be essentially on the other side of that tree for the primary residence. This item is before you today due to the exception being requested for the oversized garage. All other requirements of the zoning ordinance are being met at this time. We should note that the applicant has been working with the Rapid City Fire Department to ensure that all requirements of the International Fire Code are being met. With that, staff recommends that this application be approved with the stipulations outlined in the staff report.
John?
Thank you, Madam Chair. This almost doubles the size of the garage in the exception. And how many other neighbors have you visited with, Fletcher?
I would say, I don't have a tally here, but I'd say I probably spoke with 4 or 5 individuals in the neighborhood, including both individuals that live immediately south of the proposed development.
And the exception is there a, what is the exception to, besides the building code on the exception on size? Is there a, I've had a couple of people up there contact me, so I just need to disclose that.
The exception.
Their question has been to me, and I don't know the answer, so I didn't talk to them about it, but is the overall square footage of this property exceptional to the rest of the properties up there in Bellagio?
Are you referring to the lot size or the size of the
The size of the home and the exception for the garage.
Madam Chair.
Yes, Vicki?
Yes, the answer would be correct. What you have at Bellagio are your standard typical single-family residential homes. This is a 5.5 acre parcel. It's been on the market for some time. We've had people come in and look at subdividing it over the years, but there are concerns with building that road and such, that trying to get those building envelopes, because you saw it was somewhat constrained. There's some elevation challenges on this property. We looked at this hard too when we saw that they were looking at putting in a total of 6,413 square feet of garage and storage space. That does seem to be excessive. Then you look at the size of the house, and you have almost a 9,000 square foot home. So it kind of makes it more proportionate to someone who would have your standard 3-bedroom, 2-bath home that wants an oversized garage. If it weren't such a remote area, and if they didn't have such an open space secured around the structures that they own, that are a part of their property, we too would have looked at this a little differently. Just also to disclose, we did have the owners of Bellagio come in yesterday, look at the house plans and the structural plans for what they call the shed, what we call a second garage, and they did not indicate any concern with that.
Thank you. Is this posted so that the neighbors all know? So it was posted. All right. Well, that answers my question. Thank you very much.
Karen? Oh. Andy?
I think Vicki answered my question. I think in regards to the fact that the lot size is so large, I think that it's an acceptable use. It won't be further subdivided in the future if this is what they're doing. So I find the use to be acceptable in that regard. So.
Karen?
Thank you, Madam Chair. I have a question about what's in the staff report from the transportation planning staff. It talked about having a road that, and you indicated that road that goes through there, but it said when it was platted that it could be, it would have to be up to Collector Street standards, and I didn't understand that. I thought this was a platted lot.
The intent of that comment is to put the property owner on notice that the major street plan does show that in the future would be a collector street if down the road they ever did want to subdivide. Because of the placement of the shed on one side of this road and the house on the other, it's highly unlikely that we would ever see this being subdivided even into 2 lots. It's truly encompassing the whole 5.5 acres as one residential home site. We still want to put them on notice, though, that right-of-way would be secured if, let's say, the neighbor to the north came to them and said, would you grant us an H lot, so that they are ensured that we would want to see setbacks to that road if someone farther to the north would ever want to do development. And it does meet that requirement as far as how these structures are located. We wouldn't have conflict between those two.
Okay, so you're talking about if it's replatted or the northern property is platted?
Or an
that would-
H lot would be secured for future development to the north.
Okay. And the other comment then was, there was a comment about removing the shed, and that's the shed that was in the picture? Okay. Okay. Thank you.
Jan?
I'd just like to ask, what would be the result of the precedent set? I've noticed in other cases that when we approve exceptions or variations, the next time that comes up and we don't want to approve it, we still have to because the court will say, you approved it in this case. I just want to know if this sets a precedent, or if there's a way to separate it from any additional items coming up in the future.
Vicki?
Thank you, Madam Chair. That is an excellent question, and that's why we have the criteria we have for a conditional use permit. It's very specific to the application. We have the ability to go through that checklist and see what are the impacts on that neighborhood. What is the size of that property? Are they accommodating the drainage and the utilities, and are they providing buffering? Do they have characteristic standards that are typical of what's already there? So if we would see a more standard urban lot that would be from 6,500 square feet to maybe 10,000 square feet, obviously we would never have the room for a request of this size. So the size of the property somewhat dictates what we may see for an oversizing request for a garage. If we couple that with the criteria that's set before us, we can go through and identify where it may be appropriate in one location and not in another. And I'll just complete that statement by adding that in this particular instance, because there is a significant amount of separation from the last platted lot to where they're placing their home, and that they do own the 5.5 acres that surrounds it, we do see that they are securing that buffer that we would be looking at if someone else came in with a similar request.
Any other questions? If not, I'd entertain a motion. Motion's been made and seconded. Eric made the motion. All those in favor, please say aye. Aye. Opposed? One opposition. Any other items? John?
Thank you, Madam Chair. Could I direct a question to Dale Tech, please? Dale, I'm going back to drainage. I'm just on my drainage kick this morning. And I happen to live in an area where there has been just extensive development, and I'm sort of at the low end and where we live. So I'm one of those people with drainage issues occasionally. But you had mentioned and referenced earlier, does the city have like a drainage plan, something that you spec off of for approval of additional development? How does it work when there's just tons of development? Does that plan get updated, or are we still working on something that was designed 10 years ago for measuring runoff and drainage?
Very good question. The city is broken into 21 separate sub-basins. We've got 21 individual, they're called drainage basin design plans. And they look at the major components necessary to convey the stormwater in those 21 sub-basins of the city, ultimately to Rapid Creek. They're constantly updated. Every time a subdivision comes in, we check compliance with that drainage plan to make sure that the subdivision is in compliance with that. And if they want to do something different, that they have to update those plans to ensure that the original work in the plan is not being done incorrectly or having an adverse effect on somebody downstream or upstream. So yes, we have a fairly comprehensive set of design plans for the entire city, and that's what we go to for every subdivision.
Okay, and they are updated as you go along, and there's more driveways and rooftops and,
That's all considered in the original plan, and that goes back to our zoning regulations. The plans look at what the zoning is, and you can make assumptions of what the runoff is based on what the zoning is going to be and what level of development you're going to have. And then the plans identify the size of your drainage structures for that level of zoning.
okay, I think that answers my question. So just to clarify, what I thought I heard was that the plans get updated by zoning, not by any determination by hard surfaces that are created in that zoning.
That's correct. When the plans are written, they assume that this whole area is going to be residential development, and you can make assumptions about what the runoff is going to be. In fact, if you follow our zoning regulations and our land use that we have, those numbers are almost exact. So when they develop, they don't have to worry about, well, geez, we're going to be so different from the plan, we've got to do something different. Our zoning process over the years has really intertwined with the drainage to make sure that we've identified areas in town that are going to have higher runoff via commercial or industrial type uses or residential. So they're tied together and they're reviewed constantly.
Thank you very much, Dale.
Vicki?
So in layman's terms, if you have a property zone low-density residential, our zoning ordinance says that you can have lot coverage of up to 30%. They then can identify the impervious area, and they can compute the drainage accordingly. Compare that to commercial or industrial, where you can go up to 70 and 75% respectively. They also then can review how that needs to be accommodated. Thought that might help.
Any other questions? John?
Vicki, that raises another question. So when we have people come forward and ask for rezoning, and it might have been ag and now commercial, we have a pretty big adjustment to that drainage plan, correct? So is that something we should be considering, or do you guys consider it before you bring it forward?
And we do. And part of the comments that we will share back with the applicant is that there may be concern, especially if it's an area where we know that there are drainage issues, and that usually creates a little conflict with the applicant because they don't know what they want, how they're going to lay it out. But we still want it to be addressed that the master drainage plan for that basin can accommodate that maximum allowed impervious area. So yes, as we look at the criteria for a rezoning application, that's one of the things that we get to look at.
Thank you.
Any other questions? If not, I'd accept a motion to adjourn. Second? Second. Motion was made and second. Meeting adjourned. All those in favor say aye. Aye. Motion passed.
No.
You can go get it.